Good evening, ladies and gentlemen. Welcome to the May regular meeting of the Planning Board. Would you please take the roll?
Yes. Thomas Callahan.
Here.
Rupert Friday.
Present.
James Grundy. Here. Stephen D. Simone.
Here.
Dr. O'Neill.
Here.
Mr. Chairman, and 5 members present.
Thank you. The first matter on the agenda is administrative matters. Staff, do we have anything we need to discuss at this time?
Not at this time, Mr. Chairman.
Okay, thank you. We are scheduled for a public hearing for 649 Point Judith Road, a comprehensive permit for development of 4 units of housing on Point Judith Road. I understand there's a request for a continuance on that.
Yes, I believe the applicant's attorney is here.
Mr. Doherty.
Hi, Mr. Chairman. Patrick Doherty for the applicants. I am requesting a continuance because my principal expert witness developed a very acute and troubling medical condition that he's been treated for. I have the liberty of speaking to Dr. O'Neill and identifying it. It is a very serious issue that he comes out with some strength. He's not able to get up out of his chair right now. It's coming to the door. And so in the interest of judicial economy, I'm requesting a continuance so that we don't have to break up into 2 parts and give one presentation to the board. Hopefully next month.
Okay, thank you, Mr. Doherty.
We would need a date certain in order to keep all the notices went out officially by mail, so I would request.
Is that microphone on?
Oh, I'm sorry. There was a light on. It was red. Forgive me. Do you want me to repeat that?
I don't think it's necessary. Do you need to repeat it, Jack?
No.
Okay. Okay, so would somebody, in terms of a date certain, what do we look like in terms of calendar, Jill?
Sure. Bear with me, I'm not sure, unless Ms. Petrone knows the date of the June meeting.
Would be the 3rd Tuesday, June 16th.
June 16th, yes, thank you. So I just want to point out, Mr. Doherty and
Oh,
Mr.
yes,
Chairman.
we would extend as well. Ms. Sabo informed me again, there was a June 7th deadline. We're fully amenable to kicking that out another 30 days or more if you need it.
Okay. So is there a motion to continue until our June meeting, which is scheduled for June 16th? Second?
I would second
So-
that with the condition that we also extend the date 30 days to match the extension of time for the hearing.
And I've spoken with my client. I have full authority to stipulate to that.
Okay, with the condition that Jim has added. All in favor?
So, Mr. Chairman,
I'm
just
sorry.
point of clarification, 30 days from today or 30 days from the deadline date, which is June 8th?
An extension of 30 days to the deadline date.
From the
That would
deadline.
extend the
From
deadline.
the deadline, 30 days?
Yes.
Excellent,
Right.
thank you.
That'll be in July.
Right.
Yes.
Okay, I'm sorry. So with that motion, the motion as Jim has amended it, all in favor?
Aye.
All opposed?
Thank you.
So be it. You're welcome. There is, looking perhaps to check on one thing. How many people here tonight for the Narragansett Pier Railroad or Boone Street Market matter? Okay, so what we're going to do is I'm going to ask the board for an opportunity to take that issue up next, D2. Move that up because, again, we have a motion for a continuance there. We have a request for a continuance, not a motion for a continuance. So is there, can I have a motion to move up the Boone Street Market matter?
So moved.
Second?
Second.
All in favor?
Aye.
Aye, okay. So we have been informed, I don't know if Jack, are you here? Yeah. Mr. McGreen, who is the attorney for the applicant.
Evening, Mr. Chairman. And so I had an opportunity to discuss this matter with the town attorney for the planning board. And there's some concern as to whether or not we've applied for the correct relief. The attorney for the planning board seems to think that we might have to request for an expansion of our use because it's of what we're asking for. Quite frankly, I haven't had a chance to research the topic. We were prepared to move forward, but obviously, if that's an issue with the town, my client agreed to extend until such time as we can figure out what the appropriate request for relief would be, or don't reach agreement and move forward and let the chips fall as they may.
Any questions from members of the board? Any comment from staff? Okay, so there would be a motion to continue to a date certain?
I would say July, to give
July?
both sides enough time to do the research needed to come to a conclusion as to what relief we're going to need.
Okay. Is there July, no objection to July?
How about staff?
I think staff, July works?
Oh, July is fine for staff. It is, I just wanted to give you the date. It's July 21st.
Okay, so this is a motion to continue to a date certain the item D2, the Narragansett Pier Railroad, Boone Street Market Matter, until our July regular meeting.
So moved.
Is there a second?
I'll second, but I have a question.
Go.
Do you want to, this part of discussion, if the application has to be changed, then this application would just expire on its own, and there would have to be a new application with new notice?
So, right, so there's a little bit of confusion here. This is a public meeting, and it's not a public hearing. In a public hearing, the meeting would need to be continued to a date certain. If Mr. McGreen, for some reason, can't, or for whatever reason, the application couldn't be heard, it could simply be moved to the next month that it was ready and ripe to be heard.
But if it was a different application,
The application would need to be amended.
it would be amended, okay?
Yep, it would be amended administratively before it came to you,
Okay,
unless it was,
without notice, without public notice.
oh, no, it's definitely going to be
Oh, so
publicly
it would be
noticed again.
re-advertised if there was a change in the application.
So the application hasn't been advertised in the newspaper yet because it's not a public hearing, it's a public meeting. So it's advertised in accordance with the law for a public meeting, which is the Secretary of State, the town's website, and of course you folks, and anyone who's on Notify Me, they'll get notified, and you can find it on the website as well. It is, when it moves to the zoning board, it becomes the public hearing, and that is the advertisement that goes in the paper 14 days in advance for all of the butters and within 200 feet. And if the relief were to change at that point, yes, it would need to be re-notified.
Okay, thank you.
Are we ready to vote? Motion to continue to our July meeting. There's been a motion made. Is there a second?
Second?
All in favor?
Aye.
All opposed? See you in July, if not sooner.
Thank you,
Ken.
Mr. Chairman.
Take care. Okay, the next order of business is the item C1 Clark Road subdivision, the final plan review for Clark LLC, Skycap LLC, Plat V, Lot 27, major subdivision, 5 lots. I am going to recuse myself from this matter. I'm going to, and Doc will take over for chairing the meeting, so, excuse me.
Well said. I'll do a brief introduction, because this introduction could go on and on. It's a long-standing application, for whatever reasons, and a very interesting piece of property. So the owner applicant, Clark, it's on Clark Road. The area is zoned R80. The density use determined was moderate to low density, and I guess we have a decision deadline, is that correct? June 8, 2026?
Yes, so again, the timeframe deadline is ironically the same date, June 8th.
Okay. So just briefly, background, owner record, that's to me irrelevant, but in any case, the site located, I said R80 on Clark Road. consists of a single lot comprised of 894,546 square feet of land, an R80 zone, and currently it's vacant, and the proposal is to divide Lot 27 into 5 separate lots and a public road, public right-of-way. And those areas would be, again, well above 100,000, 113, 122, 272, 244, and then the road taking up about 29,000. These areas are inclusive of the wetlands present on the site. So I would, as I said, we got, a lot of stuff here, and I don't think that's necessary to go through page by page, because you're going to hopefully summarize your proposal and where we are, and we'll go from there, okay? Mr. Resnick? Yeah.
Mike,
Is that on?
turn your, yes, thank you. Nope, press the button. There you go.
Are we live? All right. Thank you, Dr. O'Neill. Michael Resnick on behalf of the applicant and owner. And as you noted, this project does have a long history. In fact, I was not the original counsel. God rest his soul, Matt Callahan started this project back in, I believe, 2017. So for the benefit of the public, we are at a public meeting. This is final. We've got a master plan. We've got a preliminary approval. Respectfully, many times for a 5-lot subdivision, something like this is treated administratively, but the previous board saw fit to see this as a public meeting. All right, so I think for that reason, I'll go over a little bit of the history very briefly, just so some of the board members that were not on understand the history here. So there was a master plan approval for this project back in 2018. There's also zoning board approvals and special use permits that were obtained in 2020. And this project has a freshwater wetlands permit along with a RIPD's permit, and that was dated in 2024. And most recently in 2025, this project received its preliminary approval, of course, with conditions that were required of us. And again, as you noted, it's a 5-lot subdivision, approximately 20.54 acres. There's a construction of a new roadway, right-of-way, intended for future town acceptance, and there is an irrevocable offer that's been reviewed by your legal counsel in your file relative to that. Municipal water infrastructure, stormwater management systems reviewed by DEM, conservation easements, robust conservation easements. Mr. Chairman, as you know, this was subject to numerous environmental studies. Scott Rebido was our wetland biologist, ultimately resulted in a substantial conservation easement on this property. And for the benefit of the public, that means a substantial space of this property can never be developed. It will be protected in perpetuity, and that is protected by our HOA materials. I would note, and Mr. Friday knows, those were very heavily vetted at preliminary. I'm going to get to the HO documents, which also include the declarations of restrictions and covenants. I'm going to get to it in one moment because there's one minor change that we made. Again, extensive environmental protections. There was a baseline study required. That's been done by Ecotone's Ed Evanivzes. Excuse me, I always butcher his name, something to that effect. He did that, and he'll be providing or incorporating the Conservation Commission's comments into that baseline report. And that's the document that will be used by the HOA to ensure consistency with the requirements of the conservation easement for testing and the like. Again, master plan approval, zoning board approval, wetlands approval, and just wanted to know, one of the issues that came up from the last time we were here is one of the checklist items was an appraisal, and it was for purposes of the fee in lieu. And the fee in lieu is required if a certain degree of development in any particular development is not provided to open space. All right, so using the town's formula for this property, .32 acres of open space is required. The applicant is giving 17.05 acres. I was an English major, but I think that's like 50 times the requirement. So it's our position that we have more than satisfied the fee in lieu requirement. We did do the appraisal because it was a checklist item, but I've conferred with legal counsel. I believe there's a memo in your agenda that speaks to that issue. We feel very confident that that has more than been met and that there is no fee in lieu applicable to this project. There's a whole letter I wrote, but I don't want to go into it at great length. As far as the HOA maintenance structures, there's going to be perpetual conservation protections, as I noted, stormwater inspection obligations, maintenance obligations. The town has enforcement rights, lien rights. There are access easements. There's biannual inspection and reporting requirements, and there's DEM compliance obligations. And I think you'll recall, and Mr. Friday, I think we had a specific conversation. There were some questions about what testing was required under the DEM regs. We went the most conservative. So there's no question that we put the most robust mechanisms that DEM provides for as far as testing. You also have an irrevocable offer of dedication proposing the conveyance of the roadway infrastructure, the public drainage infrastructure within the right-of-way. But I want to make clear, because this was part of our discussion previously, the public improvements of the roadway, the drainage within the right-of-way, the water infrastructure. The private HOA improvements are the detention systems, the bioretention areas, the private driveways, the conservation areas. And so that's been delineated. I worked on that with conflict counsel, and I don't want to speak for her, but I think we feel comfortable that we delineated that appropriately. And that's really all I have. I've reviewed the staff report. There's numerous conditions. We have one request, and that's with respect to condition number 7. And I'm going to ask if Mr. Hanson, our engineer, could address that number 7. But before we get into the particulars, based off of our review, fire marshal, town engineer, public works, building official, conservation commission has all signed off on this. As I noted, normally these are administrative, but we're happy to come back before the board. And that's really it, other than our one objection to condition 7. And Dr. O'Neill, if you wouldn't mind, Mr. Hanson, if you could address that condition, and if you wouldn't mind also just providing your credentials for the board first.
Hi, good evening. My name is Jeffrey Hanson, a principal with Millstone Engineering, project engineers for the subdivision. I'm a registered professional engineer in the state of Rhode Island and been practicing for over 40 years in the field. So the question that we've got is, condition 7 require them prior to the final recording of the final plan. It puts the tail before the dog in such that these lots, we don't know what the exact footprint would be. The lots haven't been marketed yet, so the details of that would be ironed out when you do the actual OWTS permits. And to do that prior to final recording would only require, in most, probably all 5 instances, to have them redesigned in the future. So I don't understand the logic between having, about having final OWTS approvals prior to the recording of the final plan, and that's the question that we've raised.
Have you discussed that with staff? Why they think that's a good idea?
No, but we'd be happy to hear about, frankly, it seems a little bit unorthodox from what I usually see and what Mr. Hanson sees, and there is a protection to the town. I mean, obviously, if the OWTS isn't obtained, you need a sanitation system, there's not going to be a permit. So, but obviously, we'd be happy to respond to the concern.
No, this is the first that Mr. Resnick has mentioned it to me. So if the board is accepting of that, then the system suitability, I understand what he and his consultant are saying. If it's acceptable, it makes sense that you wouldn't be able to pull a building permit until there is an OWTS permit approved on site. So therefore, it could be, Dr. O'Neill, it could be revised, should the board choose.
Okay. Agreed?
Mr. Chairman, with that, our engineer is here to answer any questions about the plan set. Respectfully, this project in many ways is vested as to master preliminary zoning approvals that were obtained. Our job was to ensure that we met all of the conditions and that we revised the plans accordingly. And I believe we've done that. And I think that that's evidenced candidly just by the sign-offs of the various departments. I understand that this board is presiding over it. Had this been administrative, that's what we would have been looking for fire and engineer and the building official to sign off. So I think we're in a good position. I think we're ready for a vote this evening. Mr. Friday, I know that you had asked that I draft kind of like an outline of some of the measures in the conservation easement, and I know that you also passed along to your planner a proposed letter, and I'm fine with that letter. In fact, we can take the one that I did and you did, and we can put them together. Yeah, there's no problem with redundancies. It's important that the homeowners understand, and you're right, a title work and any purchaser who's dealing with an attorney should know what they're buying into, but there's no reason that we can't highlight it. And so the highlight would be, it's recorded in the land evidence records, it's a condition to the approval, it's incorporated, and now we have these letter requirements that we'd be happy to meet.
Can I ask you about this? We were just handed this declaration of restrictions, covenants, easements.
Oh, yes.
Creation of Clark Road Homeowners Association.
Yes, thank you, Mr. Chairman. That is the one thing that I did forget. So, at the previous hearing, there was the discussion that lot number 2 does not actually utilize the roadway that's going to be accepted to the town to gain access.
Do you have one of these? Just point out lot 2.
Yeah. There you go.
You have it?
Thank you. Sorry, my.
Lot 2 would be, have direct frontage right on Clark Road. It would not have any access to the proposed new roadway.
Yeah.
So in fairness of that owner, to participate in the homeowners association for the maintenance upkeep of that area, they get no benefit out of that. That's why the option to remove them from the HOA is being requested.
So, Mr. Chairman, that was discussed. I had expressly requested that we have some time to think about it. The condition asks that it be dealt with by the board at final if one of those changes were going to be made. It really has to do with the funding of the HOA, and so simply what we did, and certainly it's subject to your solicitor's comments, is in the appropriate sections, we basically defined work that was HOA common area work that was outside of that roadway maintenance, and then we defined area work that was within that roadway maintenance, and we simply removed lot 2 from any obligation to pay the fees associated with the roadway maintenance. So the percentages were just changed. It's going to be a fully funded HOA in any event. And I don't want to put her on the spot, but I didn't even catch it. Your solicitor and experience from other towns said, I've seen that before, and it's caused an issue. People have come back after and said, why am I paying for a road I don't use? And the concept here is we don't want to have any fights with an HOA, and we don't want to have any fights about how it's funded. So I thought it was a fantastic idea, and we just incorporated it. And I think it makes sense.
Right. But they're still part of the association. The
Absolutely.
homeowners association of the
Yes.
entire parcel. Right. Okay.
And I highlighted in yellow in the 2 spots so that it would be pretty clear. And it's not magic language. If there was something that there was any objection to the way we phrased it, fine. I just tried to do it simple. Yeah.
Nothing else? Staff, attorney? No. Okay.
So as I said, we don't have a presentation in chief. If there's questions for our engineer, we'd be happy to do it. And other than that, I thank you for your attention, and we would request a vote
Well,
in favor.
you know, the order here will ask if the board members have any questions of you or your engineer, and then we'll go to the public, because I'm sure we'll have a few questions from the public.
Yeah, and I would just know, I don't have any objection to the public speaking. It's not my style. But I just do want to put on the record that this is a public meeting, it's not a public hearing, and that the issues before this board really are limited to final. So I just wanted to suggest that there are certain things that we've vetted many times at master and preliminary, but with that, I understand, Mr. Chairman. Yep. Yep, again, no objection, just putting on the record.
Yeah, there we go. How did that happen? You have to have one of these folks out here who's an electronic wizard to figure this out. So, questions, board members?
I have a quick one. I actually also, let's see. You got me? Okay, there we go. I have a quick one. I actually also flagged condition 7 for the reason that you flagged condition 7, but also, and maybe my memory's failing me, I thought that you were going to do one of these with sewer. Are you abandoning your plans to connect one of the units to sewer? Because I see you have depicted possible on-site water treatment systems for all 5 lots. I don't know if you're just planning on picking one later, or if you're just abandoning your right to one sewer hookup.
That remains to be determined. The only lot that has the option to tie into the sewer is Lot 2, the one that has direct frontage on Clark Road. The other lots, I believe that we went before the sewer subcommittee in town requesting connection to the sewer, and we were denied, and that's why we're forced to go back to the OWTS. We have subdivision suitability for all 5 lots. That's what the basis of the approval would be, and so it remains to be determined whether they go back and request connection to the sewer for Lot 2, or if we go back and just do the OWTS, which we have the option to do.
All right, thank you. And since it seems like we might take that out anyway, I don't think you'd need to change it to 4. So that was my only concern.
And Mr. DeSimone, just to let you know, too, about the sewer issue, we had attempted to get all these lots on sewer. It got stuck at the sewer subcommittee, which at the time was 2 people, and it got stuck on a 1-1 neutral, and then it went up to the town council, and at that time, the sewer connection was denied. The conversation was not about the environment. Instead, it was that these lots would be better as low and moderate comprehensive permit housing. So we were denied it, and that's some of the delay in this project, is we had to go back to DM. We were a little bit surprised, given the area, that there wasn't a sewer connection approved, but we did what we were told.
Thank you for the background.
Yes, sir.
I was just wondering if either staff or council could explain the fee in lieu of and why that may not be applicable, because as I was reading it, I'm going to say it's a little bit of a word salad in the ordinance.
Can you hear me?
Yes.
The subdivision regulations require all development to provide open space for the residents. The initial assumption was that because this subdivision is a standard subdivision and not a cluster or a conservation subdivision, that there wouldn't be any open space, so they would have to pay the fee. When I looked at it, my first impression was that because the vast majority of the acreage of the subdivision is going to be protected from development in perpetuity by a conservation easement, there really wasn't any need to provide any additional open space or the fee in lieu of open space. Jill was not so sure about that, so she wanted to think it over, and she did think it over, and we discussed it. I discussed it with Jill, I discussed it with Mike, and I feel very strongly that legally we are making the correct recommendation to you, that the subdivision satisfies the open space requirement with the conservation restrictions in place.
And there would be no way for that to ever be modified in the future by, so that...
No, that portion of the legal document is enforceable by the town. That would mean that if the owners of the property wanted to change it, they would have to get the town's permission. I think pigs would fly first, so I don't think it was ever going to happen. I think it's protected just about as permanently as any open space in a cluster subdivision is protected.
Okay, thank you.
Yeah, and I would just add, if I may, Mr. Grundy, and I think your solicitor and I actually dealt with this in another municipality. No, there's not a mistake. This has robust protections because it's a condition of the approval. It's a declaration. It's just essentially like a deed. We've dealt with the fact it's going to be incorporated into the deed. The other issue is this, that there's actually a statute in Rhode Island that makes that if you're going to change one of these conservation developments, not only do you have to go back to the town, but you actually have to go to the Attorney General's office and request permission. Nobody knows about it. I'd be happy to put that in there. The point is this, that conservation area is never going to be developed in any way. And I'm not saying this disrespectfully. That conservation easement, I've never seen anything like it. I've never done a project where there's a conservation easement that requires the type of testing or baseline. I'm not saying it doesn't happen, but it's pretty robust. And I'd be happy to work with Karen as a conditional final to put that little AG statute in. It would be one added protection. Karen, I don't know if you agree with me on that, but.
I did have a case like that. It was the nightmare from hell. Yeah, if we wanted to add a reference to the statute, which I believe is Title 34, Chapter 39, we could do that, and that would mean that that the conservation restrictions would have permanent protection under state law.
Okay, thank you.
It'd be somewhat superfluous, but you don't play around with the AG, so.
It's like,
Just one
it would be
more.
like a belt and suspenders.
Yeah.
But if Mike wants to do it, that's okay.
Yeah, I don't think that there's any harm. My client has no intent of those areas ever being disrupted, so.
Thank you.
Hold on, Jim.
I'm good, Doc, thank you.
So, Mr. Resnick, so two questions. One, the condition for DEM prior to commencement of site alterations, buffer identification markers must be installed. Are they installed, or is that done for the wetland buffer?
Jeff, can you take that one?
I'm sorry, which condition are you referring to?
So this is a DEM condition, number 21. Prior to commencement of any site alterations, permanent buffer markers must be installed along the limit of disturbance at locations.
Right. And your question is?
Are they installed?
They have not been installed
Okay.
yet. We haven't got final approval yet. Upon final approval,
Then
then
you
that
do it.
that condition
Okay.
would be met as all the other conditions would be.
Okay, cool. And then the second, really, Mike, is with you. So I wasn't here when this subdivision started, as you were not, but what's your understanding is the basis for the conservation easement?
Protection of the environment. I don't mean to be curt, but
Yeah,
that's my understanding of it. The exact, to protect flora and fauna, amphibians, reptiles,
Yeah.
the waterways.
I guess I felt like it really is about the wetlands and the amphibians there, the vernal pools and
Sure.
stuff, so. Anyhow, when I looked at the baseline document, I feel like it doesn't meet the standard that we put in there, meeting the standards of Land Trust Alliance or the Natural Resource Conservation Service. And an illustration of that is if you look at the purpose, in the baseline document, it doesn't even reference wetlands. And if they looked at the conservation easement, the language of the conservation easement, that's pretty clear. There's factual errors in the baseline document. So I really would like to have somebody that has experience writing a baseline document. The part of that, as it's presented, the only piece that couldn't have been done by AI is the photographs.
Well, I mean, I tell you, that one of the issues I have with that is that we did retain an expert, and he is a wetland biologist. And
But
in fact, we couldn't, well, if I might
it's-
just finish.
yeah.
I mean, the problem that I have is the document wasn't peer, and this is no disrespect to you, but the document wasn't peer reviewed. There's nobody here that's a wetland biologist that's telling me that what he did is not appropriate. He's not here because we didn't hear about those types of concerns. We saw the document from the Conservation Commission. We agreed to incorporate those. I mean, the problem I'm hearing is, you said it doesn't meet the criteria, and I don't want to start asking planning board members questions, but my question is, why? How? Because I don't understand that comment. It's a little conclusory.
So-
And we paid a lot of money for a wetland biologist to put together this report that has the credentials, and he stamped it. So I'm just suggesting, saying that he did it AI, or saying that he didn't do the work, you're saying that he affixed his stamp to something, and that's a lot for me to hear, candidly.
So my concern when we talked about the baseline document originally was that it was going to be the wetland report from the previous wetland scientist. And frankly, that was better than this baseline document is.
Well, I'm not gonna comment on it, because I'm not an expert. I'm not gonna testify for my expert. I believe we met the condition. And so.
So the conditions are that it be prepared to the standards of the Land Trust Alliance or the Natural Resource Conservation Service. I think if you submitted this baseline document to either of them, they would say it's not.
But we weren't required to do that. We certainly can.
No, but that's the standard that's in the condition.
I understand that, but the problem is that I went out and retained a wetland biologist that deals with all the regulations and the issues that you just suggested, and he put his stamp on it. And I'm disadvantaged because I'm not going to rebut what you're saying. He's not here. I also candidly question what information is before the board that suggests that what was done was not correct. And I don't think that there's any other than your opinion, which I respect,
So-
but I don't understand the basis of it.
So this is my expertise. It's not just my opinion.
I understand, but he's not here. I can't rebut it, and I don't understand what you're basing that upon. I have no correspondence. I don't know
So-
what date is missing.
So the baseline document references.
It would have been nice if we found out this issue before the meeting, because we would have addressed it.
I just got it this weekend to review. So the baseline document reference in the report is a guidance by Carol Trocchi, guidance that I commissioned. And if you look at the guidance in Carol Trocchi's, it's not what's being used. It's not the basic stuff that she has in there. I mean, it has the headings, it has the category areas, but the content for some of the areas just isn't there.
Okay. Well, I don't know what your suggestion is. We believe that it was appropriately put together. It was submitted. It was stamped. I understand it's your expertise, but there's nothing before this board other than what our wetland biologist did. Is there a suggestion for how we resolve this? Perhaps there could be some feedback given to us, and administratively, we could work that out with staff to make sure. This project's been going on since 2018.
I understand.
8 years
I understand.
for a 5-lot subdivision, and now we're at a final meeting. Respectfully, this should have been done administratively, and I don't understand it because we're finding out now. I have a planning board member rebutting my expert's testimony. I didn't know about it. He's not here. Nobody asked that he be here, and we fulfilled the condition.
The condition is that it's prepared to the baseline standards of the Land Trust Alliance or the Natural Resource Conservation Service, and it's not to that standard.
And the only thing that I can say is that my expert understood his charge. It was discussed with him. He reviewed all the approvals, he reviewed all the conditions, he submitted a plan, it was stamped. This was not identified by the Conservation Commission when they reviewed it, and this is the first time I'm hearing about it. And I'm not sure that what I can do other than to say, I rely on my expert. I've used him many times. I have no issue with his work.
But
I'm not going to rebut what you're saying, because it's not my discipline. And I didn't review it in the way that you did before this hearing, because I didn't hear any issues about it prior to showing up.
I reviewed it this weekend.
You know, in fairness, this report that we're looking at is dated June 25th, 2025. It's a year old. I think if there were concerns with it, with complete respect to everything you said and your expertise in the field, I think at this hour, it's not a fair thing to come back and make a claim that we're not going to accept or aren't happy with a year-old report.
So, Mr. Grundy, we didn't get it a year ago. Just
Oh.
clarification, we didn't receive this a year ago. We received it with the final submittal.
Oh, okay, because it appears the document was created.
It may have been. But, Mr. Resnick, confirm that you submitted this?
I'm not sure whether it was submitted prior to. I'm not going to suggest that Jill's wrong. This application, that piece of material is, I think, has been in the town's position for 60 days. I mean, maybe there's a way we could work this out administratively, and perhaps Mr. Friday could work with staff. I mean, I don't have any issue going back to the expert and asking him to revise a couple things, but to come back for another public meeting on this, I'm not sure I understand.
And just for confirmation, yes, it was submitted with this final application. Was not submitted to us a year ago, correct?
And has the Conservation Commission had the opportunity to review this report?
They did.
And their report and their findings on it are included with?
They should be included in your packet,
Right.
yes.
So if they didn't take exception with it, does?
They did have commentary regarding it, but I'm not sure they have the level of expertise that Mr. Friday does.
So just to be clear, I'm not asking for another meeting. I just would like the baseline document prepared to a standard. It's the basis for enforcing the conservation easement.
Sure.
There's not enough language, and like I said, the wetland report that was done before has more detail than the baseline document.
Yeah, I'm just trying to understand how we're going to get a sign-off on that. If we're trying to be creative and avoid another meeting but make sure it's done, that's fine. But with all due respect, Mr. Friday, you shouldn't be the sole arbiter about whether or not we've met that. I'm not really sure what to say. Again, it comes down to this. Just like my civil engineer wouldn't put his stamp on plans that are presented to you that he believed were not in accordance with the regs, neither would this gentleman. I mean, that's all I can say.
So, but he's certified as a wetland expert.
I
He's not
understand, but I'll
certified
give you an example. I was just at a hotel project in Bristol, and there was a gentleman that is a wetland biologist, civil engineer, he's got all the disciplines in the world. And he took a lot of issue with the approvals we got from DM, and he let everybody know all the technical reasons and all the standards we didn't meet. But DM approved it, so DM disagreed with him.
So you could have agreement from the Land Trust Alliance and the Natural Resource Conservation Service that it meets their standards. I mean, I'm trying to be less.
But it already went through them, and they
It
didn't.
has not been to either of them, I'm sure.
I'm sorry, what is the name of the commission it was sent to?
Conservation Commission.
Right, that's the town's body.
But that's not the standard in the condition.
Could I make a suggestion? Could we add something to the final approval that says, to the extent that the baseline document does not meet the required standards, it will be modified by the applicant?
Yes.
That would be good, and I'd be willing to work with your consultant to help them.
Yeah, I'm sure that Mr. Evans would like to hear about why his stamp shouldn't have been placed on the documents and why it was not written by artificial intelligence. I'm sure he would love to answer that.
That's not exactly what I had in mind. What I had in mind was, I think you will agree that no one has more experience than Rupert in this area. He will be able to identify specific things that are not included in that baseline and suggest to your consultant that they be added.
All right, and then that would be a condition to the final for
Yes.
permits,
Yes.
building permits?
And I think the information's already there. It's in your wetlands studies.
Yeah, I think,
It's just not included in the baseline document.
Okay. We would agree to that condition.
okay.
Anything else?
Yep, that's it.
Just a couple of things before I go to public. I know it's in the document we have here, but I'd like publicly to say again that, remember, we spent years on the comprehensive plan, and this was a perfect example of clustering. The owner of the property decided not to do that. This is America, so you have decisions and choices. But in any case, why the planning board strongly suggested that at the time in order to try to keep most of the wetlands untouched. And I guess the only other thing that I would mention in passing was you probably told me, but I don't remember what you told the board. In the homeowners association agreement, the idea of if people rent their houses out, the idea of short-term rentals, I think the concern was that shouldn't the wording be in the homeowners association that these have to be at least 12-month rentals? And I think you said the owners don't want to do that.
Well, as I said, the intent of the owners is to sell these units as single-family homes, but we're not going to restrict the properties in that way. We did discuss, I understand why you're bringing it up, Dr.
Yeah.
O'Neill. It was brought up at master, it was brought up at preliminary. Respectfully, my hands are tied. My clients are not going to restrict their properties in that way. It would be an unlawful condition, so
It would be unlawful?
it would be an unlawful condition.
Is that right?
Yeah.
What does our counsel say? Would that be unlawful? As far as rental goes, it has to be,
Specifically what?
Sure, I think that Dr. O'Neill is asking about us agreeing to restrict the individual lots for no short-term rental activities. It's also been foreclosed, so there's, with due respect, there's two questions. One is, can you do it at all? The second is whether or not you can do it at a final, and we discussed it, and I don't think you can do it at all, but.
I think that that's the kind of issue that lawyers would get rich arguing about, and there might not be an answer. I can't answer it at this moment because I don't know the answer, but I would suggest that if the concern is that short-term tenants would not have the same concern for the environmental restrictions, I could only say that the environmental restrictions would be enforceable against the property owner, whether or not the property owner was occupying the property.
at the time, okay.
Yes.
Yeah, okay.
And Dr. O'Neill, I would just note that the zoning code allows it in this district, so you can't create a condition that runs afoul of your zoning ordinance.
Right. This is America. So we'll go out to.
For the time being.
Public, yeah, for the time being, yeah, that's true. We'll go out to the public.
Thank you.
Sure, where did he go? He's hiding out there. Public comments? Anybody want to step up to the microphone? Tom's not? He's saying no. No? Ah, here we go, a brave soul.
I'm Tom Warren. I'm sure you remember me. I've spoken, in fact, I testified about the rental issue at one of your public hearings. This project started in 2018, 19, and since that time, there's been many zoning changes here in the town of Narragansett, and there's been many changes in zoning from the State House. So in particular, I look at the footprint of each one of these buildings, and I have two questions. can the buildings be expanded now to what the original intent was? And the second one is, can ADUs be added to these properties? Do we have an answer? Okay, thank you.
So is there a condition for ADUs, you mean?
Yes, I could, if you give me one moment, I could bring it up verbatim, but there's a condition that if there were ADUs done, that they would be done in accordance with DM regulations and state law. But I can, if you give me one moment, Mr. Chairman, I can give you the exact language.
I think the restriction might be that, there might be a restriction against accessory buildings.
Let's see what it says.
That's my recollection. Yeah. So conceivably, you could put an ADU within the principal dwelling, but then again, you would have to meet the requirements of DEM, and you might not be able to on that lot.
Right. Thank you for bearing with me 1 second. Any further subdivision of this plat and/or any increase in the number of dwelling units in the plat, whether they are principal structures or accessory dwelling units, shall require DM review or, if applicable, DM approval before an application to the town for such a subdivision or increase is approved. So I can't say whether or not an accessory dwelling unit could be constructed on this property in accordance with that as we sit here today, but that's the condition from preliminary. So I would suggest that the issue is foreclosed. It was dealt with by way of that condition. We're not agreeing to not do an ADU because ADUs are in certain criteria by right, by law. But I don't know from an engineering standpoint or constructability standpoint or practicality standpoint whether or not they could be built. I could just say that this provision is somewhat superfluous because it's saying if you need DM review, you're going to go to DM before you go to the town, which is fine. We agree to it. But I can't speculate, and I don't want to tether a future owner of the property. That would be another deed restriction. You know, we're asking private lot owners, give away some of your bundle of rights, give away your short-term renting rights, give away your right to do an ADU. I don't know if it will be done. There's no intent to do it that I'm aware of. My clients are not designing these as short-term rentals. Anybody can look at this property and know that that's not what they're going to be, but I can't promise it. Can't promise it. It would be disingenuous of me. Was there one other? I'm sorry. There was the DM issue, and there may have been one other item that I missed, Dr. O'Neill. I don't know if I addressed all your concerns.
It was the footprint question.
Right.
So from a town perspective, if the footprint did not encroach into a setback, Dr. O'Neill, if the footprint didn't encroach into a setback or trigger any additional relief from DEM, the footprint could be modified. If it didn't trigger any additional relief, the footprint could be modified, which was the question that Mr. Warren asked.
Thank you.
Thank you. Any other comments from the board members? And how about staff?
Not at this time, when we get to conditions.
So, in the world we live in here, we are coming to a motion, aren't we? Any brave soul sitting at the table here? Putting together a motion? There's no hurry, we have until June 8th. Can we all hear what you're saying?
Absolutely, absolutely, sorry. So Mr. Grundy and I are talking about the conditions, and there are 15 original conditions. Staff would suggest modifying condition 7 to read that all OWTS permits for lots 1 through 5 are received by the town prior to building permit issuance or sewer connection as applicable. Condition 16 was a revision to the conservation easement to refer to the Attorney General statute for permanent protection of the conservation easement. And 17, myself with that care. Would be, yes, thank you.
Would that be just amending number 2?
The last one would be, to the extent that the baseline document does not meet the required standards, the applicant will work with staff to provide missing information. Is that okay, Rupert?
Right. Or we could revise number 2 to say that, Rupert, Mr. Friday.
Yeah.
Yep.
Yeah.
Would we have to recognize the modified condo docs?
Yes, you would need to recognize the modified condominium documents, and you would also want to incorporate conditions 8 through 12 of the preliminary plan approval, which remain unchanged.
So before we get the findings, I would,
Mr. Friday?
Yes. So also number 1 and number 4 in the preliminary plan remain unchanged? Sorry, it's the number 1 and number 4 as well as 8 through 12 on the preliminary conditions.
so at this point, we'd make a motion to approve with the 17 listed conditions and reiterating numbers 8 through 12 from the preliminary plan. And was there an additional number?
1 and 4.
1 and 4 also from the preliminary plan.
And Mr. Grundy, are you accepting the modification for condition number 7 as well?
Yes, that the OWPS permits for 1 through 5 will be received by the town prior to the issuance of building permits.
Or sewer is applicable for lot 2?
Yes.
Motion?
That was the motion.
Okay. Any second on the motion?
I'll second that.
All in favor?
Aye.
Aye. 4-0. Go in
Thank you
peace.
very much. Have a good evening. Appreciate it.
Right. The real chairman is approaching. Would you go out to the Boone Street Market for a beer?
Thank you, Dr. O'Neill. I think you've done such a magnificent job that we might elect officers again soon. Okay, so might I ask, there are a number of people here this evening. So are you here for Brooks? Okay. So what I'd like to, in the interest of managing your time, I'd like to ask the board's permission to move item D1 under D1 site review for Brooks, Plat L, Lot 1-12, 39 Major Honor Road. We take that up at this time.
So moved.
Is there a second?
Second.
All in favor?
Aye.
Okay. so be it. So, just for the public that's here, in terms of the relevant background, the location of this project is 39 Major Arnold Road. The applicant is seeking to demolish an existing dwelling with a set of improvements and build a new house. The project requires a variance and a special use permit from the Coastal Resources Overlay District and variances from the dimensional regulations, section 6.4. Property is also located in a special flood hazard district, item number 4.7. I assume you're the attorney representing your client?
Yes, thank you.
Could
Matthew
you-
Grunberg with Bush and Kavanaugh.
I'm sorry, Matthew.
Grunberg, Gruneberg.
Mr. Grunberg, the floor is yours.
Thank you very much, Mr. Chair. So our firm represents Miss Alexandra Brooks, the property owner of 39 Major Arnold Road. And before you tonight is Ms. Brooks's proposal, as you stated, to demolish the existing four-bedroom home that's currently on the property, to rebuild a four-bedroom home that is FEMA compliant, further away from the coastal feature, completely out of the VE zone, is safe, intended to last for a lifetime, and will conform to the character of the neighborhood. As you might recall, this application was before you on November 18th, and this is actually a continuation of that hearing. The design from that night is unchanged. So the drawings that are in front of you, the design team here, Mason, Talia, and Lindsay, did a very thorough presentation. I think they answered a lot of the questions you had that evening about the technical aspects of the construction. But there are two changes from that evening. The first was a major point of concern for the board, and that was what was referred to as the Westerly case, which is the McLeod case. As you know, in July of 2025, our Supreme Court issued a decision related to the Westerly zoning ordinance. And in that case, they held that the strict language of the ordinance meant that someone who wanted to demolish and rebuild their home was not afforded the luxury of seeking a zoning variance. Now, the night that our design team presented this to you, I think that might have been one of the first times this issue was presented to the board. So there was some extra information that needed to be clarified before you felt comfortable moving on this application. So what the town has done since that time is they worked with a team of attorneys, they worked with the planning board. Our firm was involved in creating a text amendment to the zoning ordinance, to section 9 of the zoning ordinance, which expressly allows an applicant to seek a relief from the zoning ordinance in the form of a variance when they wish to demolish and rebuild their home. So that issue has been clarified now, and we believe, I think we're one of many who are moving through that funnel now that that has been straightened out. The second point that is different from the first time around is that the building department has reviewed the variance requests and they've adjusted some of the numbers involved. So the first is the floor area ratio, which I know was discussed at the November 18th meeting. And that number has actually been adjusted down. So the applicant is now seeking 163 square feet beyond the allowed amount. Now, it's worth noting or reminding the board that although we are seeking this variance, it's minimal. I think it's 8.6%. It's within the administrative modification realm if we weren't in the 4.4 coastal overlay zone. But the design is reducing the site coverage from 27.5% down to 20.5%, which I know was discussed at the previous meeting. So this is really minimal relief that we're seeking, and the number's been adjusted down by the building department in our favor, we believe, and we hope you feel the same way. The second variance, which the building department has adjusted, is our request for height relief. The applicant is seeking height relief here because, as you may recall, they're elevating the structure because of the flood zone requirements. So we're going to have a ground floor level that is the garage. It will have breakaway walls, allow for the flood waters to pass through. Hopefully that never happens, but as the board mentioned last time, our storms are changing and it may become an issue. Then there are 2 floors above that, which are the living areas, which replicate the living space, which is at the existing dwelling. So without the height variance, Ms. Brooks really would be losing half of the existing living space. So she's really just requesting to take what's there, move it up to a safe distance, and develop the site in that way. The building department has referred us to the table in zoning ordinance 6.4, and they've determined that the separation between grade and the base flood elevation is 4 feet. Now, if you refer that number to the table, that means we're allowed 27 feet from the base flood elevation to the top of the building. This means that we're requesting 4 feet, 2 5/8 inches of relief. We do have 2 points on that. Looking at the site plan and the plans that have been developed by Mason Calisi, we believe that the grade to BFE is really around 2.5 feet, which should afford us an extra foot, lowering our variance request to 3 feet, 2 5/8 inches. I think in any event, it's still minimal relief. It's necessary for this project. And that 3 foot, 2 5/8 would be, again, within that 15% modification realm, but for the 4.4 overlay. In the alternative, Mr. Calisi and the design team have moved the principal structure entirely out of the VE zone. So if you were to apply the traditional 30-foot grade to peak, then we would be requesting 3 foot, 10 1/4 inch relief. I think in any event, we're between 3 and 4 feet. It's minimal, it's necessary for the design, and it is really meant to replicate the living space that's there now, but in a much more safe and lasting design. The applicant's not requesting anything abnormal or elaborate here. We have 8-foot ceilings. We have about the minimum roof pitch that you can have for this site. So they are very conscious of the surrounding neighborhood and the need to keep the massing as minimal as possible. Now, the applicant's design team is here tonight, Mason, Talia, Lindsay. You heard from them back in November. If you'd like, we can represent a lot of the material we did before, but I think in the name of efficiency, they're here to answer a lot of your questions if you have them with this updated information. Otherwise, Talia and Lindsay do have some photos of the surrounding neighborhood which they'd like to present to you, just to demonstrate the character of the neighborhood, how it exists up to, I think it was 3 days ago, just to show that this design does conform with the character of the neighborhood and with the goals of the comprehensive plan. In addition, Ms. Brooks, the applicant, and her family are here tonight, and she would like to provide a supplemental statement just to give some background on her time in Narragansett and her vision for the home moving forward as a lifetime home. So we do want to incorporate the testimony that was given at the November 18th hearing. We would like to reiterate that in the application materials, there's a geotechnical report prepared by FR Engineering Group, and that the town's engineering department has supported this project with an approval letter back in September of '25, I believe. So at this time, Talia and Lindsay, if you'd like to pass around those photos, if the board will have them.
Before you do that.
Certainly.
I have a question to my left from Dr. O'Neill first.
Yeah, you touched on something that, the idea that you can take something down and rebuild, but you're doing it in a cautious way, you're moving it to a safer, location. Didn't we have a gaggle of attorneys in here a month or two ago? Because they all said they all had clients waiting, because the way the law is stated, you can't move the foundation. Where are we with that? I must have missed it.
Yeah, it was, I think, the Attorney Guenberg mentioned it earlier. There were a series of attorneys that were working on a proposed amendment.
Yeah.
It went to the council referred it to us, we reviewed it, we sent it back to the council's adopted it. So that issue has now been resolved, Jack. I mean,
So so the council did
Yes.
that? Oh,
Okay.
all right.
so,
I missed that.
and before you invite your folks up, is there anyone on the board who would like either a refresher from the team here in terms of what's actually happening here, or has everyone got in their minds what they need to know for tonight? Good? Good? Are you good, Rupert?
I'd like to see the floor plan again.
Of
like
course.
Old compared to new.
Of course.
Okay.
Sorry, old dude, short-term memory.
Sure, and Mason, would you like to speak on the floor plans? We do have, I think the site plan represents the existing conditions.
The site plan would be the only thing that we have representing the existing conditions. There are no existing conditions drawings of the current floor plan, but the site plan,
But you're asserting that the existing house living space is the same as what you're replacing it with?
yeah, based on the property record held by the town, and that would be the only record that I could offer to prove that currently in our presentation.
Yep.
Okay, Mr. Guenberg, you can proceed. As you laid out, you have some additional information
Certainly, if
the
the
team
board-
wants to present,
if the
and
board
then
would
you
like-
want to hear from the owners, right?
Yes,
Okay.
thank you. If the board would like to accept these photos of the surroundings and add those to the record.
This is all, but it's different shots. Different shots. So it's all, this is one exhibit. I just, for the purposes of getting it into the record, that's all.
Thank you.
Okay, great.
Good evening, board.
Okay, good.
I'm Lindsay Seddon. This is Talia.
Talia Formicola.
So there was some concerns last time, just making sure that the property fits into the neighborhood that is there now. We did take, in the larger packet you have, it does show this is our client's home right here in the middle, and the two properties, actually the whole property on the street, everything has been built up. So there's a lot of new construction going on there, and similar in height and variance. The photos before you, the first two photos show what we are looking to build for the client to show that it fits in with the neighborhood. That would be these two photos here. So this is what we are proposing for the client's house to look like. Discussing back to the floor plan that is there now, there is 2 bedrooms on the first floor, and there is a kitchen and a living space. That is exactly what is going to be there now, when, well, if we get the chance to rebuild it the way we want to. And then upstairs, same thing, there is 2 bedrooms upstairs with a living space as well. So we are keeping the same amount of bedrooms on each floor and the same amount of living space on each floor.
The bedrooms don't make sense in the current home right now.
They're triangles.
Oddly shaped. We have a spiral staircase going up to the second floor, and it just does not seem like you could properly put any furniture in any of the bedrooms. So either way, it would have needed to be gutted. And obviously wanting to keep the longevity of the home, that's when Wayne gave us the okay that we could knock down the home instead of lifting the home 10 feet.
The picture that you have here is the direct neighbor to the left who is rebuilding. The following photo is the direct neighbor to the right that they didn't knock down, but they did extensive renovations. The next few photos do show all the houses in the neighborhood that are 3 levels and very similar to what we are about to be hopefully building for the client, just to show that there are other homes in that neighborhood that are similar.
And to show that this home does reflect other homes in the neighborhood. It's not like we're doing anything, you know, out of style, out of sorts. It fits in with the neighborhood. And we just want to make sure we're building a house that lasts for our clients. So going up is the way to go.
Does the board have any questions for us to answer?
Questions at this point? Rupert?
I don't really have any questions. I still have concerns about the floor area ratio. You have 3.5 bathrooms, and, you know, the description says
She
this.
has a large family. She has a lot of family from Rhode Island.
But the reason floor area ratio was adopted was because people were putting very large houses on small lots. So it was to keep the proportion. And since it was adopted, the town's removed calculation of the garage from floor area ratio. So it's even a much bigger house than was envisioned when the floor area ratio was adopted, so.
We are going to let the homeowner speak as well, but we do want to say that you can see in our floor plans that we are very conservative on space. We don't have a crazy large master bathroom with, you know, an 8-foot shower in there. We try to keep them as small as possible as well. Alex, would you like to speak?
So could you identify yourself and what your role here is, please?
Hi, I'm Alex Brooks. I'm the homeowner.
Thank you.
So thank you for hearing us tonight. I appreciate it. I'm living in Florida right now, but I was raised in Rhode Island. I grew up in Providence. I graduated from URI. So this is a chance to have a home for my family to use. My family is here tonight, so my whole family is still based in Rhode Island, so it'll be nice to come home. So when I bought this house, it was a 4-bedroom. I have 6 kids, and so I need the space, you know, for my kids. I'm having my first grandkid coming up in September, and so we really want to use the space as a family house. In looking at the fixed area ratio, my technical team can answer the questions more. What I'm really looking to do is looking to take the space that's in the existing house and reproduce that space. So I'm not looking to build a McMansion or really, you know, go overboard, but I do want something that will comfortably fit my family, including kids and grandkids. And you guys know, it's like you need a bath to bathe the grandbabies in. People come from the beach, they need a quick shower. So that's really all we're looking to do with this space. And we were trying to very much stay within the existing footprint of how much square footage is in the existing house and just make better use of the space that we could. In terms of the garage on the first floor, I'm in the Fort Myers area, and we got hit really hard with Hurricane Ian, and it completely destroyed a lot of houses because they weren't built to withstand the storm. I have a property in Clearwater. Hurricane Milton hit us, and we're still rebuilding there. So I was very conscious about buying a waterfront, shorefront home, that I wanted to make sure that I was environmentally conscious about the way we're building, but also that I had sustainable for the property to ensure the property value. You know, homes in Florida can't even get homeowners insurance anymore because of the extensive damage done, and we know the climate is changing and storms are more severe. So that was at the front of my mind. When talking to my design team, it was a must-have for me that the first floor be able to allow storm surge to come through, and that living space was moved to a higher elevation, not only to protect my investment, but also to just protect the coast and the property also. So that was the front of mind for me going into the home. I'd be happy to answer any questions, but I really just wanted the opportunity to share with you you know, my thoughts going into it, and the fact that this was is going to be a family, a place for family to come and get together and be together as Rhode Islanders. Thank you.
Thank you, Ms. Brooks. Can I ask staff a question? On this issue of floor area ratio, if you had to calculate the floor area ratio for the existing house and compare it to the proposed floor area ratio for the proposed house, what would the difference be?
Excuse me, Mr. Chairman. So without having, sorry, I have a tickle in my throat. Without having the existing floor plans in front of us, it'd be hard to calculate that number, and we don't like to do math on the fly just because we don't want to misspeak. But based off of the footprint of the existing dwelling, if it was 2 floors and both floors were living space, it would be about 0.3. That's not removing any of the staircases, and that's not considering if the bottom floor was, you know, entirely living space or what the actual layout of the floor, the floor space is. So that would be about 0.06, and I don't know how many square feet that is off the top of my head, comparatively difference. But again, that's not entirely accurate because we don't have the existing floor plans, and the building official has not calculated that number.
So help me understand. I'm not going to hold you to a specific number, but I am looking for kind of an order of magnitude difference, and directionally how material that number is.
Well, for example, the the relief being sought is for is 0.3 comparatively to what they're asking. So on top of the required 0.35% for FAR. So they're asking for 163 feet over the allowable, and you know, a quick rough estimate would the difference between the existing house and what's being proposed is 0.06. So I would think it would be less than 100 square feet difference. But again, that's not. Don't quote me on that. We don't have the floor plans for the existing space, so we're not entirely sure if that's correct.
Okay, thank you. I presume you haven't done those calculations on your side?
When we had our first meeting, we weren't asked to provide those. I know we did walk through the floor plan the first time, but we don't have.
That's fine. I did, it
Yeah.
just didn't, if you had the answer, it would be nice, to know, but it's a question that just occurred to me as I was listening to you tonight.
Based on the existing tax assessment, the living square footage of the existing house is 1,990 square feet, if my note is correct, and our proposed is, if you might, what did the town give for the FAR calculation? Because it was different from what we had given initially.
I'm sorry, Steve, you got it?
It's 2,065 square feet from the town.
So we're talking less than 100 square feet.
Okay, thank you. Okay, go ahead, Jill or Amanda.
Sorry, if I may clarify. So in the relief requested,
I'm sorry, I can't hear you.
in the relief requested,
Yes.
under the FAR variance, there's a typo, so it should be read as 0.03 instead of 0.3.
0.03.
Yes.
Thank you.
And just to make note, FAR is based off of the net lot area. The net lot area in this case is 5,435 square feet instead of the gross area of the lot.
Okay, and and the area that's netted out is due to the coastal feature?
Correct.
Is that right? Okay, thank you. Okay, is there anything else that you'd like to add at this point in time?
I believe that's all. If you have more questions, we will certainly
Okay.
try to address them.
Sure. So I'll go down the line here and see what questions the board might have. Starting with you, Jim?
No, I don't have any questions.
How about you, Steve?
I did have one question. Do you know why the town adjusted the square footage from 1,888 up to 2,065 square feet? That might be a question for staff.
I can answer that. So originally, when the applicant submitted FAR calculations, it wasn't calculated correctly. But under the re-review from the 2026 regulations, the building official made an adjustment based on a calculation from the outside or exterior walls of the home as opposed to the interior walls of the home. And I believe that that was a conversation that was had with the applicant, between the building official and the applicant.
Thank you for that clarification. So we're talking dead space in the walls, making up almost 200 square feet, and they're over by not quite 160 square feet. So I'm satisfied there.
Is there, just for my own edification, is there not any exclusion on a staircase and at least one floor to disclude the staircase or exclude the staircase? Yeah, when I had kind of reverse engineered the number I had seen in your guys' report, it didn't look like there was an exclusion for the staircase. I could be misremembering, but I'm just curious.
Your interpretation would be correct. If that's the case, we will, in between now and the zoning board, we'll ask the building official just to clarify his computation of the FAR.
That's fine, because it was my understanding that this house was actually less than what was existing at the house currently.
Sure, yeah, we'll have the building official double check his math.
Thank you.
Rupert?
So just to clarify that last discussion, so the FAR includes the staircase?
On one floor.
Okay.
Or it should, based on what you guys are describing, correct?
Yes, that's correct. So typically, in all fairness, Ms. Sabo just reminded me, we have a new building official, so there's still a learning curve that's going on between the two offices. However, yes, what that gentleman has stated is correct, that typically one staircase on one floor of a structure is removed from the FAR calculation.
But we don't know if the number with the 163 square feet excludes that or includes that?
That's correct. That's what we'll double check in between now and zoning.
And is there a, if there is one that's, if the staircase is included or is to be excluded, do you have an order of magnitude of what that number might be? No.
I have no idea.
It just
depends on how big the staircase is. But anyways, if the staircase is excluded, then the number is correct. If the staircase is included, then the number will be smaller than what you would approve anyway.
Okay.
I was never very good in mathematics. Didn't need it too much in my profession. But in any case, how can probably staff explain this to me? How can we go from almost 28% existing building lot coverage down to 20.5% and be over with FAR?
I'm sorry, Mr. O'Neill, could you please repeat your question?
How does that work? We're going from the existing building lot coverage of almost 28% down to 20.5%, and yet we're over in the FAR, floor area ratio.
This point was brought up at the November 18th hearing, and I believe Mr. Khaleesi can speak to that.
Yeah, pretty simply, there's a lot of deck space. There's actually just more footprint in general at the existing house. The footprint of this house is shrinking, and the covered area of this house is shrinking between the lack of deck space that's detached, or not detached from the existing house, but the existing house has substantially more deck space, has a covered shed attached that contributes to the lot coverage, and I believe the actual dwelling itself is just a little bit larger in square footage. And then there's a rooftop deck where you only have a partial second floor in the existing structure, so the lot coverage isn't really indicative of the square footage of the dwelling.
Okay, is that all you have at this point?
Yes.
Okay. Staff, is there anything at this point in time you'd like to add? No. Is there anyone here from the public who would like to speak? There's not. Okay. Any further either questions or comments from the board? Steve?
One quick one, good catch. I've got 126 linear running feet as the exterior of the building. You divide that by 2 for a 6-inch wall, and you get 63 square feet. But that might be per floor. So you add that, you get 120. So there's still, there's some play in that number somewhere. I'm sure our new building official will get right to the bottom of it for you. Good catch, though.
Yes, we'll have him double check.
Okay, and nothing further from staff right now? Okay. Go ahead.
Can I ask another question? Maybe this fellow can answer. The pictures that we showed, there are 2 houses down from you is a house that's really tall. How did that happen? Do you know, or obviously,
I feel like that should be a question
we
for
as a
you.
board are not happy with blocking the view of the water, you know, so.
Well, I think it's likely due to the VE zone that house likely lies in, and that would disallow any, any living space being below or at the BFE, or you'd have to be above the design elevation, and the elevation of the land over there is, I would say, is fairly similar to ours. It's a fairly flat area, and so minimally, they'd have to be 3 or 4 feet off the ground if they were to, if they didn't want to have any covered parking. And so because they wanted a garage, I assume that that's how they got where they were. And I'm also guessing that because of how long ago that was built, there were less height regulations at the time, so it was easier to do that.
Yeah, okay, before they, okay, yeah, thank you.
Okay, if there's no further questions from the board, and is there a?
Public? Nobody from the public wants to speak?
We offered the public.
You did?
Yeah, I did.
I fell asleep.
That's okay. I can understand, Might there be a motion from a board member on this matter?
First of all, you need the motion for completeness, don't you? Yeah.
Yeah.
Move the application before us is complete and in conformance with town comprehensive plan.
Is there a second?
I'll second that.
Any discussion? All in favor? Aye.
That's only the first motion.
A motion on a recommendation to the zoning board.
I would make a motion to have a positive recommendation to the zoning board to grant all of the requested relief. I believe the hardship was not prior action of the applicant. I think that as it relates to the floor average ratio, the new structure is, I'm going to say, significantly similar to the existing structure. Potential is even smaller. My other concern is that the height variance request is a product of a awkward BFE that falls mid-floor. And to have a conventional construction is going to require that extra relief. And then I think we have to make the findings with the, oh, we also have, we don't need the rear yard setback anymore, correct? That's been stricken. So we only have in the coastal resource overlay district to the variance of 187.2. Again, as that was explained by council, that issue has been resolved, and it's a relief that we are allowed to give, and the location of the property and the location of the coast will not change. Okay. I'll make sure I'm not missing.
I was just asking Mr. DePani, why, did you just refer, Mr. Grenny, that he's not receiving relief for section 4.4?
No, that he would be receiving it, that it's now allowed by a statute. The previous concern has been rectified by the council.
Thank you.
And that during this review, we did consider the comprehensive plan policies, LU 1.1, LU 2.2, 2.3, and NR 1.1. And also in accordance with 18.5, do we have to go through the 16 section? We don't need that at this point, do we? Or do we want them by reference? I think that, number one, it's compliant with all the applicable development and performance standards. Two, it's been demonstrated by the similar properties, compatibility with surrounding land uses. Three, the suitability of the site for the purpose is really an upgrade and some storm resiliency. Number four, again, it's going to be unchanged, a four-bedroom unit staying as a four-bedroom. It currently has water and will be, in order to get the building permit, have the appropriate sanitary conditions. Six, they have addressed drainage and erosion control. Seven, it's clearly has on-site access. Eight, they have addressed the parking requirements. Nine, the screening and buffering from the adjacent properties, I think it'd be no change from the existing conditions. Number 10, there is no public access related to this, so I think that number 10 wouldn't apply other than through the view corridors, and the houses, by testimony, could be slightly smaller. Number 11, the design does show the underground installation of the utilities. Number 12, through the CRMC assent, they'll address the environmental concerns as it relates to the coastal features. Be the same thing for number 13. We have the water quality addressed. The entire project is addressing an environmental impact, and I don't know the availability of alternatives to the proposed project. It's a consistent use going through.
Take that in the form of a motion, Jim?
Yes, please.
Is there a second for the motion?
Second.
Any further discussion amongst the board? Just one quick question. This is pulling the building, the decking that was previously there, this is pulling it back off of the coastal feature, is that correct?
Previously there, you're referencing the existing deck?
Correct.
The new deck will not be an attached deck, so it's keeping the dwelling unit, the dwelling structure out of the VE zone, but the detached deck will still be breaching the VE zone, but will conform with the FEMA regulations.
Okay. And is that new detached deck at the same in the same distance from the coastal feature or not?
I believe it's it's less. It's further away from the.
That's what I'm asking.
Coastal feature. Yes, I don't know exactly how much, but it is further away from the existing coastal feature.
Okay. Do you know what the Amanda, how much it's pulling it off the feature?
It's 0.8 feet.
0.8 feet. Thank you.
Also, if I may, Mr. Chairman, the revision in the requested relief for the variance for FAR will be updated from 0.3 to 0.3 in the conditions. 0.3.
Okay. All right, and I don't, again, this is a matter ultimately for the zoning board, but I would like to note for the record that in the overlay, for the purposes of the overlay district, this will essentially provide better protection for the coastal feature as a result of the decking being further off of what's currently there. No. Okay, we have a motion and we have a second. Is there any further discussion? All in favor?
Aye.
Aye. Any opposed? No. So it's 5-0 vote. You're on your way to the zoning board with an affirmative recommendation. Good luck.
The zoning board's mean, though, be careful. No, I'm just kidding.
Okay, I'm going to recommend that the board take a brief 5-minute break before we tackle the rest of the agenda for this evening, okay? Thank you. All set, okay. More than ready, Steve, thank you. We're actually down at C2, under new business C2. And we have taken B1, C1, D1, D2 off the agenda for this evening, so we threw those. We have C2 and C3, and then we're going to move through the items under E in terms of approval of the minutes, and then F, reports from the staff and board, and then we should be done. Awesome. All right? So with respect to C2, we have a memorandum from Scott that we had requested at our last meeting. Scott has been good enough to include that under C2, and I don't know, Scott, if you want to quickly highlight the key points that you've made here.
Yeah, so there were two issues that I was asked to address, and they're both addressed in the memo in detail. The first question was whether the high water table limitation overlay district, whether the limitations that are contained in there apply town-wide, and you can see the conclusion that it only applies in areas where the overlay is existing. And then the second conclusion was asking me to interpret the last sentence, which, as you can tell, in my opinion, does not add anything to the ordinance, to the overlay, and seems surplusage to me. The only additional item I'll raise is that I did recommend making an amendment to clear up the language, to make it clear that we're talking about the same thing, this whole lot coverage issue. So those are the three basic thrusts of the memo.
Thank you, Scott. Everyone's had an opportunity to review it. I don't know if anyone has any questions for Scott here or not. The question is, what do we do with it? And you recollect the impetus for this was an amendment that was offered by the town council as part of the several amendments that were provided and was ultimately adopted by the town council. So what we have is finally a definitive answer in terms of where does it apply, what does it mean, where does it apply only in the high water table district, in areas that are covered by a high water table overlay district. And what does it do? It essentially does nothing, apparently, is what Scott's opinion is. And his recommendation is that the amendment, that an amendment consistent with the opinion is recommended so that we could avoid any confusion going forward. So this could be handled either two ways with the council. In my judgment, and Scott, you can opine, and other people can opine as well. One is it could be less formal, which is to convey to the council in a letter that comes from the planning board saying we've asked our council to review this. This is his opinion on this. We're sharing with you that his recommendation is that there be an amendment to fix this. Or secondly, we could ask Scott to draft an amendment that fixes this and then convey that to the council more formally as is the procedure that would start a process where the council would take a look at it and then have to act on it going forward. So I'm open to doing either. I know the council has, is expecting us to provide them something on this. My recommendation would be to do something, like I said, I'm open to doing either. I prefer to give them an amendment that accomplishes what Scott's laid out here, but I'm open to hearing the conversation. So with that, people have an opinion on this.
I would just be more in favor of giving them a more formal product, a finished product to work with, rather than, I think if it were less formal, it might come back to us with a request to be formalized.
I was going to say the opposite, only because I know they're busy, but it does make more sense to give them something more formal. Also, I don't know if we should loop this into C3, talking about, is that where we're going to talk about all the problems, all the little things that are weird in our zoning ordinance or try and recodify them. So I don't know if it's better to just add this to our pile or send them I'm of no opinion, really. We could do I could even do a third option, which is just send it later with the rest of them, but whatever you guys want to do, I'm in.
Rupert?
I guess another alternative, we are working on a bunch of zoning changes that we could fold this into, so it doesn't have to be a separate public hearing and stuff for the town council.
Yeah, I guess the only thing that struck me is this was a specific proposal that came from the council as part of the original 13 amendments. And because of that, it seemed, and it was ultimately adopted by the council. And it seemed to me that, given the opinion that essentially, let's make clear, it's only in the high water table districts, and if you were seeking to accomplish something, it's not clear what you've accomplished. So we ought to get, in my judgment, we ought to kind of get that on the record sooner than later, and then have the council decide at that point in time. I presume the process would be that we'd send them a proposed final work product. I think that's the right thing to do. And then they would ultimately have to refer it back, Scott, is that correct or not?
If you originate it here and you make the findings pursuant to 452452, it would not come back here.
It would not
would
come
go right to the council for a public hearing.
It will go to the, so, that would be, the other projects are bigger projects, in my judgment, Steve. We'll talk about that in a second, but seeing that this was essentially triggered by the council in their proposed 13 amendments, I think we should work on that sooner than later. So maybe a motion that I think reflects what Jim had offered in terms of saying, let's get a formal amendment. If we could ask you to draft that for us, Scott, for our next meeting. Would that be, is that reasonable?
That's reasonable.
Okay. So could I have a motion to that effect?
So moved.
Is there a second?
Second.
All in favor?
Aye.
Aye. Opposed? No. Okay, so that's a 5-0 vote. Now on to D3. I think that is right. No,
C3.
C3. Pardon me. So this, when we made our report to the board in, I think it was March. Is that correct? Jill, was our report to the council? I'm sorry. On the original, on their last referral.
On the most recent referral?
I think it was on the original 13 amendments.
The original 13 amendments was April 8th, 2025, I believe.
No.
That was the date of your report.
Then this would have been, that's clearly later than this, later than that.
And then they came back with modifications again, the 15% modification in side yard setback, and your.
That's what it was.
Yep.
That's what it was.
Yeah, the
And-
date of your report was December 29th,
December 29th, okay.
or
Oh.
22nd.
December of 2025.
December of 2025.
December 20. So we had a set of other thoughts that we shared with him. One of them was, given the confusion around some of the terms of art within the code, maximum site coverage, maximum lot coverage, there were 6 different terms that were used. All that made some sense, but you had to be an attorney to figure out where they applied and where they didn't apply. So the question we suggested to them is that it would be useful for the town to invest in looking at the total zoning ordinance and seeing whether it could be recodified for the purposes of making it more simple. When that recommendation was provided to the council at their meeting, the town's President Pro Tem made a point to saying that's a good idea, we would welcome that if you could figure out a way to do that. In conversations with Jill, and not yet with Scott, but I think Jill has talked to Scott a little bit about this in preparation for tonight's meeting. The thought process that I had, which may or may not be the right way to proceed, is to look for a scoping document that would essentially, could be provided to the council saying, here's essentially what would be required to engage in a recodification for the purposes of simplifying the zoning code. And I think this is clearly something that would require outside help with, outside of Scott, in order to do this. And the purpose would be to provide a scoping document that could be then used for the purposes of identifying whether or not the council, because we don't have a budget, whether the council would be prepared to resource an effort like that, and with an understanding of here's the scope, here's the time frame involved, here's the kind of resources that would be required, and here's an estimated cost associated with it. I think that makes sense, but especially since we've been invited to do that by the council, but I'm willing to hear what other people have to say and do about that. And then talk to maybe Scott and Jill have a point of view in terms of what actually we need in order to pull that off, so.
So, thank you. So, Mr. Levesque and I were just discussing, I know that there have been folks, towns that have done it, and there have been attorneys who've done it, so I asked him if he could figure out from his attorney connections what the towns were. I'd be happy to reach out to that town and try to get a copy of the scope that they used, so you at least had an example of the way that it was laid out and what the, what the cost might have been at the time. I don't know if there's anything recent. I believe there's a town recent, but I don't want to speak out of school on it and not have it be accurate. But I believe there's at least one town currently doing a rezone. I don't know if it's a full recodification, but a major rezone, a major rezoning ordinance. So if you'll give us some time, give me a little bit of time, I could probably find that for you. I'm sure I can find something for you, even if it's not.
Anyone get a better idea? Anyone get a better idea? Sounds like a plan to me. Go ahead, Scott.
Yeah, I would just add to that I work with Ashley Sweet from Weston and Sampson in Hopkinton, and they do a lot of that kind of work. And you actually had a person sitting in the seat prior to me this evening who did that, or at least part of that work for Hopkinton in rewriting their zoning. So we can certainly turn to those resources and have them assist us on what this would look like.
That would be great, and I don't know if there's more than one, but it would be helpful to take a look at a couple if they're there, and then get a better sense of what we're talking about. Okay? Thank you. On to approval of minutes. We have minutes from December 22, 2025, February 18, 2026, April 21, 2026 that are in your packet. I'm going to see if there's, might be a objection to moving those as a block. I don't hear any objections.
Mr. Chairman, I have a small edit to the April 21st minutes.
Okay. April 21.
April 21st. On page 2, at the very top, it says Joe Volpe, 21 Harbor Island Road, noted he has been a fireman for 30 years and works for Narragansett Fire Department. I think that he's retired. I think he worked. Is that?
Yes, that's correct.
So it should be an ED instead of works. ED. He worked. Yep.
Or retired Narragansett firefighter, however you want to do it, Jill. I mean, Heidi, however you want to do it.
Mr. Chairman, with that edit, I move approval of the minutes as presented.
Is there a second? Second. This is for all three,
Yep.
matters, okay. All in favor?
Aye.
Aye. Any opposed? No. Okay. We're on to reports from staff and board. Planning Board liaison updates. Rupert, on coastal access?
Yeah, it's the Coastal Access Improvement Committee really is the focus of their attention right now is the dredging project for the Narrow River.
And what are they doing?
No update other than they're trying to help the town find the money to do the project.
And we sent a delegation to Washington last week, I think. A delegation of council members to Washington last week to seek resources.
Yeah, their meeting's tomorrow night. So.
Tomorrow, okay.
Yeah.
All right, good. Land conservation?
So we're still working on the Sunset Farm Conservation Management Plan, and we're also working on what we're going to do with the Middle Bridge area, revitalization and such. We'll get something else that we can't talk about, and then, what else? There was one more, oh, and then we might do another, like, trail walk with the two trails in town behind Sunset Farm, and then, I can't remember the name of the other one.
Crooked Brook?
Crooked Brook.
Crooked Brook.
Thank you. But we don't have a date or a time yet, so stay tuned.
Okay, thanks, Steve. Legislative updates on the zoning ordinance and the subdivision regs.
Thank you, Mr. Chairman. I don't currently have any updates for the zoning ordinance. Scott has them, and he's been helping us with a slew of things, so I will get in touch with Scott over the next couple weeks and continue to move that along and hopefully have a draft for you guys at some point.
Scott?
I would just add that House Bill 8004 just passed, and that's going to change the landscape more. And so I would suggest we wait for that to actually get codified before we tinker around anymore. That'll delay us a little bit.
Yep. The Senate companion for that's being heard Thursday.
Surprised it got done so soon. It usually gets done at the 11th hour. Comp plan update and status report. Jill.
Sure. Thank you. So just quickly on the subdivision regulations, same.
Oh, I'm sorry.
That's okay. The subdivision regulations, unless you wanted to go back to that.
Yeah, go ahead. I'm sorry.
Okay.
I'm apologizing.
The subdivision, same thing, that there will be some changes that are coming down the pike with this legislative session. So speaking with Mr. Levesque, we're going to hold off. And I do have a slew of changes that I provided the subcommittee as well. I'm still waiting for feedback on that. And we should be having something that includes the 2026 changes, hopefully by midsummer, mid to late summer. With regard to the comprehensive plan status report, I believe at the last meeting we talked about having a soft kickoff with this board. I polled you all offline to find out when you might be available for a different special meeting, June 8th, 9th, and 10th, and it turns out that you're all available on both June 8th and 10th. The original June 8th meeting, which I was trying to figure out for a potential work session with the council, it looks like that might not work. So could we possibly do a soft kickoff with this board and the consultant, Weston Sampson, on June 8th? And then I would ask this board to hold the June 10th day for a potential meeting with the town council.
And that's on the urban redevelopment, the work sessions on the
Yeah,
urban
right now.
redevelopment stuff?
Mhm.
Okay.
Mhm.
Gentlemen? Good? Everybody good? 8th and the 10th.
Yeah, I do recognize it's two special meetings and then the regular meeting in June, so my apologies.
8th for the soft kickoff on the comp plan, and 10th for a potential, still not locked down with the town council on a work session. Jill, everyone's good?
Excellent. So we're going to we're going to move ahead with the comp plan kickoff on, I believe it's June 8th, and then I will be in touch with you on the potential work session with town council.
Okay.
Thank you.
Confirmation of the, of a quorum for the next regularly scheduled meeting of the board on June 16th. I know I will not be here, and I'm in my absence. Doc, I'm counting on you to chair the board if you're going to be here.
Clearly, I can't fill your shoes, but I'll give it a try.
Everybody else good? Yes. Okay, good. So it sounds like you get a quorum. Is there anything else that we need to discuss tonight? If not, I'll take a motion to adjourn.
So moved.
A second? Is there a second?
Oh, yeah, second. I thought Rupert might have already.
All in favor?
Aye.